completed unless recognized again after raising their hand. At some point during the meeting, the board may choose to move into executive session. When the board moves into executive session, the board members' microphones and video feeds will be turned off, and a similar screen as you see now will be displayed. When the board returns from executive session, their microphones will be turned on as well as their video cameras. Welcome again to the Professional and Vocational Licensing Virtual Board Meeting. At this time, the chair will call the meeting to order and take a roll call, as well as explain any additional rules that may be specific to this board.
Star Advertiser newspapers. The notice stated as follows. Pursuant to Act 32, Session Laws of Hawaii 2019, notice is hereby given that the Department of Commerce and Consumer Affairs, DCCA, will hold a public hearing on Monday, July 29th, 2024, from 9 a.m. to 1 p.m. in person in the King Kalakaua Conference Room, first floor, King Kalakaua Building, Department of Commerce and Consumer Affairs, 335 Merchant Street, Honolulu, Hawaii, 96813, and virtually to hear persons interested in the proposed interim rules, Hawaii Administrative Rules, Chapter 16-121, pertaining to midwives. Please visit our Midwives Committee meeting schedule website, where you will find the necessary information to access this public hearing virtually. The purpose of the proposed interim rules is to further clarify the initial and renewal license requirements, scope of practice, and unprofessional conduct for licensed midwives by 1. Clarifying the definition of midwifery care. 2. Clarifying renewal and restoration requirements for licensed midwives. 3. Recognizing the scope of practice for certified professional midwives and certified midwives. 4. Clarifying the administration, storage, and record keeping for non-controlled legend drugs and devices during the practice of midwifery as allowed by HRF Chapter 457J-11. 5. Further clarifying unprofessional conduct of a licensed midwife. And 6. Further clarifying the basis for denying or disciplining applicant or licensed midwife. Interested persons shall be afforded the opportunity to submit data, views, or arguments orally or in writing at the time of hearing as time permits. All persons wishing to submit written testimony are requested to email the written testimony to midwives@dcca.hawaii.gov or if mailing in hard copy. Please ensure that your testimony is received by July 22nd, 2024 to Professional and Vocational Licensing Division at the address printed below so that it can be included as part of the record. A copy of the proposed rules will be mailed to any person who requests a copy upon receipt of $3.17 with a copy and postage. Please submit your request to the Professional and Vocational Licensing Division at the address noted below, or contact the Midwives Programs Office by email at midwives@dcca.hawaii.gov. Copies may be picked up at the following address between 7:45 a.m. and 4:30 p.m. Monday through Friday, excluding holidays. Department of Commerce and Consumer Affairs, Professional and Vocational Licensing Division, 335 Merchant Street, room 343, Honolulu, Hawaii, 96813. The cost of a copy, $1.30, is due and payable at the time of pickup. Further, the proposed rules may be reviewed in person free of charge at the Professional and Vocational Licensing Division at the address and hours of operation printed above. In addition, the full text of the proposed rules is available and can be downloaded free of charge from the website of the Department of Commerce and Consumer Affairs. Individuals who require special needs accommodations are invited to call Alexander Pang at 808-586-2701 at least 4 working days prior to the hearing. Nadine Ondo, Director, Department of Commerce and Consumer Affairs. I will now briefly describe the procedure to be followed at this public hearing. If you are attending in person and have not signed up to present oral testimony at this hearing, please do so at this time using the sign-up sheet at the end of the table. Testimony will be received in the order in which you appear on the sign-up sheet, if attending in person, and for those attending virtually, in the order starting at the top of the list. If you have written testimony to submit, but do not wish to present oral testimony, please submit your written testimony to the Executive Officer, Leanne Tashima, who is sitting 2 seats to my right, before you leave the public hearing today. When your name is called to present oral testimony, please take the seat located at the end of the table to my left. We ask that you state your name and if you represent a group, organization, or another individual. The purpose of this public hearing is to hear your views and comments regarding the proposed interim rules relating to midwives. Therefore, we will not be discussing your testimony during the public hearing or answering any questions which might be raised by your testimony at this time. Please be respectful of other testifiers. Please also be advised that these are interim rules, and if approved by the director, will be in effect for up to 1 year. After this public hearing, testimony received will be considered. We will also consider any additional comments submitted by August 30th on any aspect of these rules. The director intends to decide on the promulgation of interim rules within a week or two after August 30th. I would like to begin with the first person on the sign-up sheet. Ms. Margaret Reagan.
Hi,
Hello.
where do I?
Sure. If you could please take a seat at the end of the table and state your name and any organization that you're representing today.
Hello, aloha. My name is Margaret Reagan, and I am here today on my own behalf as a certified midwife. I also am a representative of a private practice, Ohia Midwifery and Wellness, on the island of Hawaii. And I'm also secretary of the board for the Hawaii affiliate of the American College of Nurse Midwives. I'm grateful for this opportunity to speak today. It isn't often that professionals and the public get to speak with policymakers regarding regulations that have great impact on their private lives and professional lives. I come to Hawaii through my grandfather, who came in the 40s, and the sublimity of this land evoked him to move here later in life, and I have more recently also followed in his footsteps. Midwifery is a pathway for me to serve the land and the people that I've grown to love over the past 40 years. As a certified midwife, I hope to make a few statements around the credential of a certified midwife and the standards that have been established by the American College of Nurse Midwives. In the 90s, there was widespread revision in the medical field of specialization in different fields. Midwifery was much the same. Research had shown that many certified nurse midwives had entered into the field primarily to become midwives. So they entered into nursing programs just so that they could then attend a midwifery program and to therefore practice midwifery. And so ACNM, along with certifying boards and organizations that I'm blanking on the names, I'm nervous, I'm sorry, but I'll do the acronyms. But anyhow, all of the group that contributed to accrediting schools and credentialing the certification of a certified nurse midwife established the CM credential in 94. And the first licensed CM was in 97 in New York. And I'll speak more to that later because I was a working midwife in New York. That's where I came from, before coming to Hawaii. So since then, ACNM Legislative Committee has worked hard to establish the CM credential. It's very hard to do that on a federal level. So it's like state by state, when midwifery licensing is considered, representatives from ACNM will come to that state and try to work to establish proper scope. So that happened here too. So I had noticed that in the home birth task force report, there was note that like, why do we need CMs in Hawaii? There are no CMs. Well, CMs don't practice, it's not a standard that they would practice without a license. It's like, they will go where licensing is established. So, I am an anomaly. I am the, only CM in Hawaii. And I was happy to hear that there's room for discussion, that today is not a time for discussion. I'd be interested in further discussion if people have more questions about it. But anyhow, what I have noticed is that there is some lingering misunderstanding of what is a CM. How it has functioned in New York is as equivalent to a CNM, and that is reflected in the regulations. So dating back to the Sunrise analysis of 1999, where there were the CNMs, who are the nurses, and then there was all of the other non-nurse midwives, which were deemed lay midwives. So that would be licensed and unlicensed non-nurse midwives. And even though in that document, it was clarified that CNM and CM are equivalent, there is other wordage that says that they are not. And that misunderstanding has prevailed, and which brings us to today. So there is precedent in other states where there are midwifery programs that regulate a variety of different credentials for midwifery, licensed and unlicensed. So there are states where you can have a description of what is midwifery and then what are all the credentials. And it's a little bit similar to the Hawaii administrative rules for nurses, where you have the APRN. This is true for all nurses. And then there are there's a certified nurse midwife, there's a certified anesthesiologist. I don't know what all those are, but there's a way of doing it. So I guess I would like to reflect on how a CM can function in the state of New York based on precedents that have been allowed them to practice that way. So policy really matters. So in New York State, CMs work in all work environments, hospitals, birth centers, home, clinic. They have prescriptive privileges. They get they're Medicaid providers. They have DEA numbers. And I was able to provide all of that care in New York, and it's very common. So there are, I don't have the numbers, but there are dozens of CMs throughout the state who are able to provide all that. And I was able to work in a birth center and provide care for Medicaid patients and private pay patients with my prescriptive privileges and DEA number. I provided primary care, gynecologic care, pregnancy care, postpartum care, newborn care under my credential. I later worked at with an OBGYN group with hospital privileges. I had duties at the hospital running a labor and delivery floor, postpartum unit. I was the only provider on the floor. I would manage calls from the ER for OBGYN patients that they needed a consult. I would be a primary assist in C-sections. I would manage post-op delivery after C-sections. And so then after the pandemic, which did a number on me, I must say, I came to Hawaii because CMs can get a license here. And I discovered, well, CMs are not even credentialed with Medicaid yet. It had been 2 years into the program. They weren't credentialed. So I couldn't work for provide care to Medicaid patients. Without Medicaid being established, you can't establish yourself within private insurance groups, right? So they see what the fee for service is with Medicaid, and then private insurers work on that. So the only avenue is doing cash pay. for me as a CM. Or if I was to work under another provider, I wouldn't be able to have the same amount of pay, even if they hired me, but there's nowhere in Hawaii that would hire a CM to provide full scope care. Does not exist. So what I had to do was open a private practice, and provide care on a cash pay basis. So anyhow, so as you probably know, Medicaid looks to Hawaii administrative rules to establish what their fee for services will be. I've met with the Medicaid office. It's been wonderful. They understand the value of community birth care. They understand the value of midwifery care and the distinction of what happens in a hospital, like how you establish fees. Like you have your OB who goes in and checks on a patient for like 5 minutes and then goes out. And then there's all these other providers that need to be paid for within a hospital system. Compare that to a private practice or like a home birth, where it's just one provider putting in a lot of time, putting in a lot of hours. Medicaid is actually willing to negotiate a much larger compensation reimbursement rate. So in New York, for what it's worth, you for a global fee, which means from your first confirmation of pregnancy visit through newborn care through like 6 weeks postpartum, for all that care in New York, it is not uncommon that midwives are being paid $13,000 to $15,000 for that time, which is also actually not that much money for the amount of time that they're spending, because they're having to maintain their business and all that, right? So they're getting paid that. So Medicaid is open to hearing about, what we can provide. So if as it stands now, I am hoping that we can negotiate a high rate so that I can accept Medicaid patients. It would be wonderful. 40% of pregnant people are receiving Medicaid. So to not be able to do that, it really limits access to midwifery care. And there's great value in midwifery care. Its basis is in preventative care. There's a lot of research around the benefits of midwifery care to a community. And that has been recognized by Medicaid, but we need to have the interim rules established to really become an integral part of the continuum of care. So, in review of the current draft, before I go there, because this is the biggest ask, it's the elephant in the room, which is the, for whatever reason, prescriptive authority was removed in the statute. And this has been discussed at every meeting of the advisory board, what to do about this. So so part of the way that the current regulations are written is the CM, the certified midwife credential, is based on ACNM standards. Prescriptive authority is integral to that. So for example, I'm a primary care provider. What kind of prescriptions do I need to be able to provide? Someone has a UTI. Someone needs an immunization. Someone has a sexually transmitted disease. This is just primary care, right? And then gynecologic care. There are a number of prescriptions that are just integral. Contraception. I can't have all of those in a personal formulary. I can't have a variety of IUDs. I can't have like all these different things available to give to my clients. What happens in practice is insurance will approve to pay for that, like an IUD, hundreds of dollars. The insurance will approve to pay for that. With that approval, then my office gets the IUD, then I can place the IUD. So otherwise, we aren't independent providers. without that ability to order those prescriptions. I mean, it's not all drugs. Some of them are instruments. I don't see how I stand a chance to be hired in a hospital without it. Because I'm not an independent provider. Someone will always have to sign off on every drug that I would administer. Someone comes in with preeclampsia, how will I be able to, in an emergency, order all those drugs? Like, I just don't see how it will function. And so that brings it to the other point where I'm well aware that there'll be an audit of this program. If the CM, if there's someone who's considering, oh, what's the value of a CM? What could that mean for Hawaii? How will they know? Because we have not been able to do what we could do. And, you know, on a personal level, I have my own interest as to what I want to do as a CM, but for the credential and for the value of the credential, it hasn't even begun to show the light of day. Like the whole benefit of being able to avoid going through a nursing program for the people interested in midwifery in Hawaii, it's huge. So I have been approached, and I had this in my written testimony, I've been approached by a number of CNM students seeking a preceptor. They are desperate to complete their training so that they can go out and practice. Well, Georgetown University keeps hearing about how Hawaii doesn't have room. It doesn't have enough preceptors. There aren't enough CNMs who are working in hospitals that can precept, and there currently is only one CNM in the whole state who's providing out-of-hospital care. There's very few preceptors available. They've actually granted me to be a preceptor for CM in the United States. There's a CM program that is a hybrid program. So people interested in midwifery potentially could apply to that program, and they could get their training in the state of Hawaii, and they wouldn't have to go through nursing school. They could avoid the cost of the nursing school. They could avoid the time away from their family, and they could start working earlier. And those were actually all the reasons why I chose CM. It just made sense. It's like, I want to practice midwifery. I don't want to learn how to take care of men from the time they're born till the time they pass. I want to practice on being a primary care provider and a gynecologic care provider, reproductive health provider, and a pregnancy care. So I think that's the extent of my circuitous testimony. I want to thank Leanne for all of her patience with me over the years. It's been hard. You know, that I've seen how advocacy goes in other places. In New York State, the doulas are out there on the streets screaming. They badmouth, like they say whatever they want. They now get Medicaid reimbursement. So whatever I've done that has been a little pushy is because I really believe in it. I see how it works in New York, and you know, there is a true need for midwives to be a part of addressing the maternal health crisis. And we need more midwives in Hawaii that are from Hawaii, be it whatever path. You know, there are many CPMs that will speak today also, but the CM has great value here to address those concerns and to have people from Hawaii being provided the care for their communities. I think it has not been helpful that there was not a CM on the advisory board. I have to say, I think that there's a need. It's very awkward for me to say that because I am the only one that's in Hawaii. But if there could be, like, it just doesn't make sense for the credential that's being impacted to not have a say moving forward. Let's see, anything else? I'm accompanied by my wonderful president of the Hawaii affiliate, and in our testimony, and she can speak to this if she wishes, but in that testimony, we had submitted some aspects, like we saw in your version, parts of State Bill 1033 from the very first version before it went through all of its iterations. We saw how it was like cut and pasted, but there were some parts that were not included. So and I'm not going to go over them in detail, but we included those in our testimony as like, oh, these were not included. Could you consider reinserting them? We feel they're important, and we don't understand why they were removed. I understand the furnishing authority is a long shot, but to the extent that you have authority to do some kind of interim solution to fully see what this program could provide, I plea to you, or whatever the word is, to consider, to include the furnishing authority. It's exactly what is in 89C for the CNM, including exclusionary formula. So if there's questions about like, how would we run this program, or, you know, whatever, it would be a replica. It would go through the same process, and you probably wouldn't be very busy from it since I'm the only CM. But it feels it's important in the audit of the program to consider, like, so, and where that solution came from is in the state of California, where similarly, the statute for CNMs did not include prescriptive privileges. The solution was, in the regulations, they use the word furnishing, and pharmacies go with it. It worked. So, you know, I'm happy to give more background, but that recommendation to go with that kind of language came from ACNM Legislative Committee. And that is the biggest ask. And there are others, such as assisted surgery, which basically is a first assist. It means the CM stands at the side and the OB during surgery, and they are the first assist. It's very standard practice. So we have a draft in full where those suggested additions have been added in, and we'd be happy to provide that to you. It felt inappropriate to provide that without it being asked, because of course we defer to your authority, but we do have a document that's ready to go sent today. Thank you for your time.
Sorry, can I just clarify?
Yes.
You also submitted testimony via email. Is this your same testimony? Because you mentioned earlier that you're testifying as an individual, but is this your testimony?
That is my testimony. That is my testimony as the owner here. It's hard. I'm wearing many hats.
But as an individual, this is your testimony.
As an individual, this was my testimony.
So are you gonna submit that in writing? Will you just summarize? You know, we kind of want that. So what is this then, your email testimony?
It is not different. It's an elaboration of everything on there. I think I gave more personal on my experience. In my written testimony, I stated the implications of there having not been interim rules as a CM, the need for interim rules, which is happening, and what additions we hope that can be included as the interim rules move forward, and the value of the CM credential. I think I just personalized everything that I did in my thing. Leanne, if it's okay, I will reread what I wrote.
I
And
mean,
if there's anything that I feel,
just saying, since you're already here,
yes,
I mean, no sense going through the list and then you come back on again, so if you.
oh yeah, I don't need to come back on.
Oh, okay, all right. I
But-
just want to clarify, make sure you said everything you wanted to say.
But are you at, like, if I wanted, if I review what I wrote, like, will this, since this was just,
It's being recorded,
yes, no, I know, I'm aware.
so we will be drafting it from the recording.
Oh, I'm so sorry. Feel bad for you.
Right, thank you.
Okay.
Ms. Manon? Please state your name and organization you're representing today.
Hi, my name's Manon. I'm a PhD. I'm an APRN, certified nurse midwife. I'm retired, live on Big Island. And I am president of our Hawaii affiliate of the American College of Nurse Midwives. I'm here today to thank you all for moving forward with interim rules for certified midwives. The American College of Nurse Midwives helped to create this program in response to the need to provide midwifery for our country and to bypass a requirement to become an RN first. And so the credentialing of certified midwives became established in the mid-90s. So this is an example of a program that was considered on a national level that then had to be approved at the state level. So therein lies why there was some confusions and difficulties with trying to understand this role. At the end of the day, it appears that there are some discrepancies between the current draft that was submitted for the interim rules and the highest level scope of practice that a CM can achieve is credentialed for, is licensed for, is credentialed for. And that's what we're addressing today. Basically, let's add back in the pieces that really help the CM have full scope of their practice and not limited practice. And for examples, we talked about prescriptive authority. We talked about a couple other things that have been removed and should be included. I hate using the word should, but that has kind of been a problem. And we'd like to help with that. We're offering our help. We're offering hopefully some clarity of how to get it back to what it ought to be. So that's really why we're here today. We're appreciative that there are interim rules. We hope that they will be adopted, but we want to do it right. We want to make sure that all the elements are right. So someone like Margaret or any other certified midwife can come to the state coming from a practice, a robust practice like she had in New York, and be able to hit the ground running and take care of the people. So that's all I wanted to say, and we're supportive our on the ground here as the Hawaii affiliate. All the people back at National and DC support are getting this right, and so we hope that we can, muddle through a lot of these details and say what it is that CNM, certified nurse midwives, and certified midwives, we are equal. I have an RN after my name. She doesn't, but she was taught the skills of an RN. It was her certification board. Everything else has been equal. She's passed the same certification we have to, the CNMs have to. And so this is how it unfortunately didn't start off that way. And we understand that, but we want it to set it right. So I hope that we can contribute our wisdom on that. Thank you very much. Was there any questions?
Next, Ms. Guzman. Then it would be Ms. Strumpf.
Aloha, thank you for this opportunity to testify. This subject goes very deep for me personally. Yes, say your name for people. Oh, Rachel Cornell Strumpf, licensed midwife, certified professional midwife, license number 1. I've worked really hard to be here today. I've worked as a professional midwife in Hawaii since 2004 after a 9-year apprenticeship to get where I am. I'm PEP trained. I got here through the exemption of passing my credential before the deadline of 2020 with the bridge certificate. I would like to speak to the validity of the PEP process. Just like Margaret is saying that, you know, they take the same test as the certified nurse midwives, all CPMs, regardless of how you got to be there, take the same credentialing board exam. So we are all equally educated through different pathways. In the same way that an operating engineer or an electrician or a plumber can do an apprenticeship or be trained through a schooling program, we are able to be trained in both ways and have been. If you think about it, the original midwives have been around for thousands of years and we were all apprentice trained. The CPM credential started in 1993 to 1995. And a lot of the midwives in the state who are kupuna predate the credentialing processes. So that said, I thank the state, which I can't believe I do, for my license, because for me, on my end, it's helped me. It's helped me so much because I'm able to legally obtain the medications that my patients need to have safe, competent care. And that's what we're trying to do. Nobody was ever trying to be incompetent. We just didn't have a professional legal means in which to obtain the medications. But like Margaret, I have a similar problem in that I can tell a mom, you should get an IUD, and I'm trained to put them in, and I can order it for you, but I can't bill your insurance. Or you have a yeast infection and you need some, yeast cream, but I can order it for you and you can pay me for it or whatever, but I can't call it into the pharmacy. I'm not able to prescribe. Or bacterial vaginosis. It's just a simple cream, but I can obtain it. I can legally obtain it. I can legally administer it, but I cannot use a mother's insurance to provide coverage for that medication because I don't have prescriptive rights or the ability to, what's that word? Furnish the medication. I mean, I can administer, but I'm not able to, it's a technicality. It's just a wording thing that could probably be fixed really easily. As of right now, there have been 4,354 total certified professional midwives in the world. Right now, there are 2,600 of those active, and right now there are 138 active certified midwives. So the certified midwives they're kind of like our lesser known group of non-nurse midwives, and they do have a very important role in the future, but there just aren't very many of them, so they haven't been able to be as recognized, or because they're few in number. So the bill, I know when it was passed, it was really to license the certified professional midwife. And the CM was sort of thrown in there because you were trying to grant them legal status, but we haven't done their profession any favors by linking them to what type of midwife that I am, because we are completely two different modalities. We both practice midwifery, but Margaret's gone through the extensive training and additional education that you would have to become a certified nurse midwife. And so that really should be validated and recognized. as a whole, I really didn't have any issues with the rules overall. There were a few issues like emotional, can't create emotional harm of a patient. Well, I mean, if a mom has a C-section, sometimes that creates emotional harm. And if she was planning a home birth and ends up with a C-section, it could be argued that that's emotional harm. And so I feel like that's sort of a dangerous way of wording it. If you said dangerous harm due to negligence, that could be arguable, but just emotional harm, it really leaves a lot to who's determining emotional harm. I am concerned right now because I started as a doula in 1993. I was a doula. And it's a very valid thing for women who want to have a hospital birth. It's not something that we see a lot of use of in the home birth setting. It's primarily for support for women who are seeking a hospitalized model of care. And their goal is to be a liaison between the mother and the hospital so that her wishes don't get kind of like overlooked or bullied out of her, because they have a tendency to be like, you want your epidural now? How about now? Well, how about now? And you can be like, please don't ask me again. And they still come in the next shift change and like, hey, how about we get you an epidural? You get some rest. And it's like, so the doula is there for that liaison relationship, also as a means of providing comfort measures. She's there to get you ice chips, to rub your back, to squeeze your shoulders, to push on your back when you have back labor, and just to tell you how beautiful you are and you can do it and you're great and wonderful. That comes with a couple meetings before the birth, because you have to get to know them and know what their desires are and their wants are. And it comes with usually 1 or 2 meetings after to make sure they're breastfeeding okay and that, they're not depressed, because it's part of the care. So, the way the definition of midwifery currently is, doulas are technically illegal, I think was the ruling, because they cross a border for what the current definition of midwifery is. Also lactation counselors and specialists, ICBCLE, I have dyslexia. Their credentials are valid. They offer moms the ability to continue breastfeeding. And a lot of our moms are from a lower demographic. And so these are moms that will be receiving food stamps and WIC. And if we can provide them with competent and capable breastfeeding support and education, then we are able to, save the state money on formula. And we all know that babies that aren't breastfed have lower immune systems and end up with more, medical issues in the long run. So it's really a great thing to promote breastfeeding. I have been a La Leche League leader since 2002. The La Leche League was an organization started in the 50s by a group of mothers to help promote breastfeeding, support, and education for other moms or people who are birthing these days, because it's not always a mother. But the point is that, like, I'm licensed as a midwife, so I can continue to do this work because I don't have any repercussions of anybody coming on me and saying, oh, you're practicing midwifery without a license. But there are so many other leaders in this, state who are completely gagged by the current definition of midwifery. So it's not just our doulas, it's our lactation counselors. And now we have Hanai Ohana and aunties and tutus who are all like concerned that by supporting their granddaughters, their aunties, their cousins, their sisters, their mothers in birth, that they might be open to prosecution under, 457J. And so it's my advocacy that we really, the definition, I mean, we all know that definition has caused a lot of problems. So in my testimony, I did submit a recommendation for a little tweak to what you guys currently have as the midwifery law, definition. I added 2 definitions to clarify, which one would be the doula definition and one would be the definition of family. Because we all know that Hawaii is full of extended and Hanai Ohana. I mean, dating back to the Ali'i prior to the United States taking over, the queen would Hanai someone, and that was her legitimate child because she said so. And so we have to define family in Hawaii in a very Akamai way. And so I tried to do that with the definition that I submitted in my testimony. And so I really do feel that we aren't very far off the mark on a really good year of interim rules, but I feel like there's a few things that could really be clarified to so many things easier for a lot of people. That said, I am a little disappointed that the rules were put forth without another committee meeting. Being on the committee, I felt we were really making good headway and that we had a lot of really good suggestions. That said, the rules that were submitted aren't terrible, so I'm not arguing that fact. It's more of a procedural notation that I understand it's totally within your ability to do that. And I know that it's been dragging on for some time, but the rules not being implemented don't affect the certified professional midwives. They affect the CMs. They aren't affecting us in the same manner because we already don't have any of those abilities. So again, it's like, she got lumped in with us, and it's unfortunate because we are like opposite ends of the spectrum. And we all provide competent care, but it's definitely just not, we're not the same, even though we're all midwives, in the way that I'm not a nurse midwife, I'm not a certified midwife, and neither are they certified professional midwives. We are three different and very distinct types of midwives. And then there's those who shall remain illegal for the time being. The traditional midwives, my kupuna, my teacher who has 45 plus years experience, almost 3,000 babies under her belt, hasn't been able to legally practice midwifery since July 1st of 2023. So for me, it hurts my heart to see our elders being locked out of their profession. And it's said in the law that until a time when the community had a time to define themselves, and the community has tried repeatedly over and over to define themselves, to try and advocate for their ability to still practice within the exemption. And everything that's been put forward has been shot down. And I understand that I'm not a politician and I don't work in I don't have any of your jobs. I don't understand the intricate workings of it all, but there are many states that still provide a very thorough exemption with an informed consent, like Oregon, for traditional midwives to continue to work in the communities that want them. And the thing is that these are the aunties and the tutus that live in the middle of nowhere. They're in like outer Puna or Kapa'au on the Big Island, or Pahala, where it's like, haha, somebody else had a baby in the car because they live so far. They're 2 hours from the hospital. It's, safer for midwives to come to them, and they have midwives in those communities that have their hands tied right now because of the lack of extension on that exemption. So my Christmas wish list would be for me to be able to get my patients the medications they need for the conditions that I'm allowed to tell them they have. It would be for Margaret to be able to practice to her scope, fullest scope, because she's like, a unicorn. We have like a unicorn in Hawaii, and we're just like letting her, like keeping her in a closet. And it would be for the definition to just be made more, it's just, you can't define something by saying what it isn't. You have to say what it is. And that definition sort of doesn't quite hit the mark. So I am available. I flew over here from the Big Island. I got up at 4:15 this morning. I'm on 6 shots of espresso, but I should be good until at least after the meeting. So if you guys have questions, or if I can be of any service, I appreciate being appointed to the Midwifery Committee. I appreciated being a member of the Hawaii Home Birth Task Force. I sit on the Hawaii, help me, Christy, what is it? The Hawaii Home Birth Collective Elders Council. I'm also part of the NARM, the North American Registry of Midwives Grievance and Complaints Board. So I really serve my community in every single way that I can. So, and these are the things that I see that are important. So I appreciate your time and the opportunity to speak with you today. And thanks.
Thank you, Rachel. We have Jamie Lewis.
Hi, good morning. Thank you everyone for being here, giving everyone the opportunity to speak. I come as my name is Jamie Lewis, and I come as the Executive Director for Hawaii Homebirth Collective. And I just wanted to read our testimony. And then also, I had a few things that I also wanted to separate personally that I wanted to speak on. And of course, a lot of it just overlaps, but we do have a written testimony that I would like to share. So please pardon my lack of eye contact as I look at the letter, but I do appreciate you being here. So Hawaii Homebirth Collective appreciates the opportunity to submit written testimony and on interim rules that have been worked on by the Director of Midwives Advisory Committee. As the organization with largest membership of licensed midwives across the state, these rules are very important to our members. Since the birth of the Hawaii Homebirth Task Force in 2019, HIHBC has advocated the past 5 years for legislation to pass that would, number one, protect the right of the family to make an informed choice of who is at their birth. Number two, protect all birth workers, professional and cultural traditional practitioners, regardless of licensure. And number three, for CPMs from Hawaii to have access to licensure through apprenticeship using the nationally recognized portfolio evaluation process. The support of the DCCA has been very much appreciated in 2003, and we hope to be able to work together on protection of these basic human rights and practice in 2025 legislation. So thank you again. We know our work isn't done. Our main recommendation is to actually remove the definition of midwifery that was put in the interim rules. And although the definition is written totally in the actual statute, we don't feel that it is the place of the interim rules to redefine it. And so we recommend taking it out. So if you have any questions in regards to that, we are available. So myself and Christy, who y'all have grown to know over the years. So that's the end of our written testimony. Something else that we actually really want to add to this statement, though, is that HIHBC is the largest organization of licensed midwives in the state of Hawaii. We represent not only CPMs and traditional midwives, nurse midwives, and certified midwives. So the testimony that was shared earlier today about CMs being able to practice to the full extent is a priority for us too. We feel like it is really, we want folks to be able to make true informed choices, but when those choices are limited, whether it's by rules and regulation or misinformation, our hope is to get clarity and to really allow parents to make decisions for themselves. So excluding, pulling the shade on certain practices or not being fully transparent of what a CM would have the ability to provide is part of what we really want to help clarify. So it is our hope that we can all work together as we have been working together as the new regulations come out, the new law gets passed, that we can work out some of these problems that have become very visual over the past few years since the law has come into place. We also really feel like we want to speak to the exemption, take this opportunity to speak to the exemption because as we spoke in legislation, we know that there needs to be regulation per the Sunrise report. And we just want to say or make aware that the exemption is a form of regulation. It is not the strictest, most rigorous form of regulation, but it is a form of regulation. And so it is something that could be adopted and could be honored beyond that date of last year, July 1st, 2023. So, and it seemed that it was working. We'll find out in our analysis. It did seem like it was something that was working for the state. So, we don't have to necessarily just toss it out because it ended. We can re-include it if that seems like an opportunity. And then for my personal piece that I would like to add is under the piece of unprofessional conduct, 16-121-7, the number one piece of aiding and abetting or assisting an individual in the practice of midwifery. I think that is a little bit of a slippery slope because we don't have the definition of a midwife assistant. And I think that as was shared in previous committees, that midwives often have an assistant. And it is not necessarily because we don't have a huge workforce of midwives in general. For one midwife to assist another midwife means that their load of clients will get smaller because they're already on call for somebody else. So there's often somebody who is included that doesn't have their own private practice already. And so I think that it is, that's a little, the wording, or maybe that can be tweaked in some way, but because midwifery assistant is not defined, then if someone is assisting that isn't a super green student, or even a seasoned student but doesn't have their own private practice, that can actually become an issue of, are you harboring someone? Many of our younger midwives would like to work with elders or work with people who have more experience or who have attended but maybe don't want to have their own private practice. But because of the language of the midwifery definition, that's not possible. And so there are issues where a private practice is now only allowed to work with a student, but a student doesn't have the experience or the wherewithal. So if two things are happening at once, if a mother needs support and a baby needs support, and you have someone you have to direct, or even two people you have to direct through the emergency while you're trying to take care of another emergency, that is an issue. And so I just kind of wanted to circle back around. I haven't been here in person, but I have been listening in on all of these meetings. And it is something from an experienced based practice prior to the legislative, sessions of closing down my practice. It is something that is legitimate, and it is something that our newer midwives, I think, would really appreciate being able to call on elders who are now not allowed to even give information or advice. That's a major issue where we're sending people out green and we're not giving them the ability to check in legally with people who have carried that torch for decades. So that's all I would like to share. And I really appreciate, again, all of your time and your effort. I know this has been a long process. We've all gotten to know each other really well. And thank you so much.
We have Christy Duarte.
Aloha, my name is Christy Dort. Thank you for appointing me as a Midwives Advisory Committee public member. It has been my duty to represent the public in these meetings. I'm also the chair of the Hawaii Home Birth Task Force of 2019, Act 32, and I'm grateful to have served with the DCCA on that task force. Thank you for all the time and energy that has been put into putting together interim rules over the course of our 4 meetings that were called by the DCCA. I understand that this may be a really difficult situation for everyone, but it's the public who has definitely been the one who has been in the most difficult situation yet. As we received a notice almost a month ago from the DCCA that we would no longer be having committee meetings to discuss these rules, but that the director would be moving forward to a public hearing. When this happened, the public was not okay with this, and I became very concerned because in the last meeting in March, it was understood that we would come together to discuss these rules and then have a public hearing. I immediately called the Office of Information Practices, the OIP, because I had no idea if this could happen and why we could no longer have input. When I began to share information as they asked questions with me, they began to discover that we were instructed by the DCCA to not share these drafts with the public, how the drafts were not made available to the public for all the meetings we had had, and how the draft had changed from draft number 3 to number 4 2 days before our next meeting. It had also become a topic of discussion on the agenda, and testimony that day from the public was not accepted prior to each agenda item and was only received at the end. The OIP asked me more questions like who was the chair and why didn't we have a chair from our committee members? Why didn't I know how to schedule our own meetings? Why was I never shown how to do this? And they told me they had never seen anything like this before. But the reason I want to share this with you was because the OIA or the OIP attorney informed me that there were so many violations, but that it was against me. And that I was the one that the violations and the complaint would be filed against by anybody, even though I wasn't the one managing the meetings up to that point. For me, this was an incredibly scary moment and puts me in a dangerous place to think that at any point, someone can view our last meetings online and file a complaint against me for breaking the Sunshine Law. But because it's the committee who is in the violation and in this dangerous position, number one, I'm asking to please get the process back into compliance with the best practices, as I am the representative of the public. After this discussion with the OIP, I hoped to attempt to call a Midwives Advisory Committee meeting and quickly inform the DCCA, asking if they would like to help with the administrative duties for this. My hope was to keep the public process and transparency as a priority. But then it came to my understanding, which I didn't know, that the way that HRS 457J is written is that it gives the director power to do what they would like to do. But I'm asking today to do something else. It would be good for the DCCA to follow the basic public process rather than push an agenda that the public doesn't have input on through the committee members and allow us committee members to get back into compliance with the Sunshine Law. In that meeting and in other meetings, there has been a constant request, I think we've heard over and over from the public, for a moratorium on the law. That is why after our last meeting in March, I went to the governor's office and I asked him to implement his power to declare the moratorium. I did that because many public members up to that point had asked for a meeting, just public people in the community, and had had no reply. So I was hopeful he would reply to my meeting request. Number two, I'm concerned that a Akai analysis is supposed to be done in regards to these interim rules being implemented. So I'm humbly requesting the results of the analysis when it's finished to have access for that for the public. And number three, if the midwifery definition is added into these interim rules, I'm also requesting if there can be a letter from the AG to share how the interpretation of that goes with the current definition of HRS 457J that, to my understanding, in the letter could not be clarified much further. Thank you again for trying to navigate this really difficult issue as best as you can. I will be available for any questions. Thank you.
Thank you, Christy. Is there anyone else here present in person who would like to testify that signed in? Okay.
So we're gonna start calling the ones that have emailed testimony in. So the first one is Leah Minton, Midwives Alliance of Hawaii. So we have written testimony with recommendations. Next is
There's a Melissa Chong who raised her hand.
Melissa Chung.
She's with Mo.
She's with mom. Midwives Association. Okay.
Okay, sorry, I was unable to unmute. Melissa Chong with Midwives Alliance of Hawaii. We submitted written testimony and we stand by our written testimony. Thank you for the opportunity to speak.
Thank you. Whitney Harrelson?
Oh yeah, she's having a hard time trying to connect, so she would like the call-in number.
Oh, it's on the agenda,
Okay, I'll send it to her. Thank you.
and then it's on our midwives page on the DCCA website.
Okay.
Okay, while she's connecting, we'll go to the next person. Margaret, Annette Manon, you wanted to add to your testimony?
The only question is, can we submit
No
the,
questions, sorry.
oh, no problem.
Annette Manon, you want to add anything to your testimony? Wait, Margaret? Anything to add to your testimony? You can ask questions, you're just not going to answer them at this time.
If it would please the, if it would,
If you're going to address, please, thank you.
just a procedural question, if it would please, the policymakers, I would like to submit an example of the drafts that included the suggestions. Is that possible to do at this time? I guess you can't answer that question. I will,
If that's part of your testimony, you feel free to submit that.
thank you.
Marian Siliquini and Karen Kelly, American College of Nurse Midwives. You submitted testimony, written testimony emailed. Christy, you want to add anything else to yours? Thanks, Christy. Board of Directors for Hawaii Home Birth Collective.
That was me. Thank you.
Thanks, Amy. Lonani Teal.
Hello, Lenny. You should be able to enable your microphone and your video.
There she
Oh,
is.
you can now, okay. Sorry, it wasn't letting me unmute. Aloha. Sorry, let me just stabilize this because I had to change it up a little. Mahalo for this opportunity to testify. My name is Laulani Teal. I am the coordinator of Whole Paikono Peace Project, and I'm also a longtime birth worker and community participant who's worked throughout the birth community for many decades. And I'm a traditional Kanaka Maoli, defined as Native Hawaiian practitioner. So I would like to emphasize that this process really, really needs to be stopped and restarted through the Midwives Advisory Council, because number one, that was the commitment that was made by DCCA at the last meeting, where a lot of discussion was had over the rules, and that discussion, which I believe was very productive discussion, ended in DCCA saying that the next meeting would be scheduled at which they would complete that discussion and vote. That was a commitment by DCCA to the public, to bypass that process so that the public does not have meaningful input, and to write rules that are highly problematic. And, you know, my written testimony speaks to that, why they are highly problematic. I should say it speaks to it partially, and I believe that the midwives themselves are speaking to this also. It goes way beyond what is necessary and constitutional. It also does not meet the standards. It does not basically do the kapa'akai. There has been no kapa'akai analysis done as is required for this. And to my knowledge, it certainly hasn't been put out there for us to comment on. So that would need to be done. And then we needed to have an opportunity to comment to that, because as part of that analysis, you need to be able to identify the identity and scope of valued cultural, historic, and natural resources, including the extent to which traditional customary Native Hawaiian rights are exercised. So in order to do the analysis as it relates to this rule, you need to be able to hear from the people, and cutting off the public process is not a good way to do that. And then, of course, the kapa'akai analysis also requires that that you evaluate the extent to which those resources, meaning the community resources, including the community knowledge, community practices, all of those things, including traditional and customary Native Hawaiian rights, will be affected or impaired by the proposed action, meaning these rules, right? Number 3, the feasible action, if any, to be taken by the agency to reasonably protect those practices if they're found to exist. Now, one thing I want to make really clear is that DCCA does not get to get out of this because there is an injunction against them for prosecuting people who are exercising their Native Hawaiian rights, because the court did uphold that there is a court order on DCCA right now not to prosecute people for exercising these rights. However, this goes way beyond that. Yeah, these, for example, those the midwifery rules that are being put forth right now, they're being proposed. For example, they talk about aiding and abetting, that it's against the rules, that it's a violation for a midwife or a licensed midwife to quote unquote aid and abet an unlicensed practitioner from practicing. Okay, I'm going to say in Kanaka Maoli culture, the primary cultural practitioners, and I want to see this in your kapa'akai analysis when you do it, the primary cultural practitioner of hanau is the mother, is the makuahine, is the person whose body is bringing forth that child. That is the primary cultural practitioner of hanau practice. And whatever she decides, however she practices, or he, in some cases, you know, being that there are many genders, identities, that person who is conducting the hanau has the right to practice with anybody they want, putting their hands on their vagina or any other part of their body. Yeah, they have the right to decide that, and no one can say that that cultural practitioner does not have the right to determine themselves, to self-determine who puts a finger up their vagina during birth. Nobody has the right, other than that person whose vagina it is, to say who may touch them. And if those rules go against that, then they have violated the rights of Kanaka Maoli to make that determination, regardless of who it is. That person could be a Kanaka Maoli cultural practitioner. That person could be a cousin. That person could be a person could be Haole. That person could be from Mars. It doesn't matter. It's her vagina. And she is the only one who may determine herself who may stick a finger up it or any other part of their body. That is up to her, period. So if you're going to say that aiding and abetting is a violation of any rule, then you better make sure that not one single vagina cannot be determined by its owner. Otherwise, you are violating Hawaiian rights and you will be held accountable. And Christy should not be held accountable for this. And right now, Christy is accountable for this because she's been, from her testimony, she's been made to hide stuff by DCCA. And that's not okay. That is not okay to the public. It is not okay to anyone. And, you know, this needs to stop. This process needs to stop. This rulemaking needs to stop right now. It is illegal. It is unconstitutional, and it is HEVA. It is a violation of Native Hawaiian rights. It is a violation of public process, and it is a violation of the constitutions that you as a state agency are required to uphold, of the state of Hawaii, the United States government, and everything else, not to mention free, prior, and informed consent, which is a fundamental indigenous right that is throughout many, throughout all of the world. The United States is a signatory, so the state of Hawaii needs to follow that also. So I am just saying that this needs to stop. I'm not asking, I'm saying stop this process now. As soon as this hearing is over, you need to scrap these rules and start over with the committee as you committed, as you gave your word to all of us. You need to follow that, and you need to scrap the rules and start over correctly, follow the process, do kapa'akai, give the public time to comment. And then after that, we can have a meaningful discussion, meaningful rules, and we can absolutely uphold all practitioners and everything that they need, including all of the licensed midwives, all of the people coming in from other states who want their licenses recognized. And that, you know, and I do absolutely think there's a place for that, and there it is to be supported. But if anyone is saying that the expediency of that surpasses the right of the public and the right of Kanaka Maoli, I'm sorry, it does not. And I think that the court has been clear that that is the case. And I think that we need to be clear that that is the case, that the rights of everyone can be absolutely upheld. The needs of everyone to comply with insurance or anything else can be upheld. Right now, we don't have anything on the table that says that insurance is going to recognize anybody. But let's work towards it, sure. Let's absolutely work towards it, but not at the expense of the public, not at the expense of Kanaka Maoli, not at the expense of anyone, not at the expense of any birthing person who the state is trying to determine who may touch her vagina or who may decide what she needs to do. That is absolutely not okay, and it absolutely needs to stop. Now, I do need to also comment on the definition of midwifery is highly problematic and needs to be just taken out of this entire thing, because there's a definition that is in the state law 457J. It's already very problematic, but to add this layer on it just makes it more problematic because it doesn't actually protect anyone. And it doesn't address fundamental problems such as Kanaka rights, as such as the many other things that need to be protected. So I say scrap that part. It is absolutely unnecessary and not good, and hopefully it will not be an issue, because the process itself needs to stop right now. I'm just saying right now, Director Ando, if you put forth these rules, there are going to be problems, and you need to stop, because this process is wrong. It's incorrect, it's illegal, and let's just not go to battle over it. That's my proposal right now, is let's not go to battle. Don't waste my time. I don't get paid for this, you know. I don't get paid for battling you guys, and I don't want to do it. And I think neither do a lot of other people who are watching this right now. And I don't want to, so let's not do it. So I don't want to see any finalized rules. I want to see a public process, a correct process, a right process that respects everyone who needs to be protected first and foremost. Mahalo.
Great. Melissa. Was it?
Whitney,
Whitney.
you should be ready.
Thank you. I see you guys have your hands up. Krista, Pacific Birth Collective, and Pua. We are going in the order that we received. So first we went through the people who are present today, and then those who emailed testimony. So email testimony. So we'll be calling you in a few minutes. I gotta warn the rest of you, this hearing is only until 1 o'clock. We're not putting a time limit, but I'm just asking if you can be courteous to your fellow testifiers. If not, we're gonna run out of time and we will not be able to hear them, or have to put a time limit towards the end. So I'm just saying, I understand you want to present to the director and staff, but I'm just saying, we are gonna run out of time if everyone's gonna have 20 minutes. Melissa?
Whitney, you should be able to enable
sorry.
your audio and video.
She's trying to call in now. She said her connection. She does. Not good, yeah, in Maui.
Okay, we'll come back to Whitney then.
Okay.
Oh, wait, she's on.
Hi, everyone. Can you hear me?
Yes.
Hi, I haven't been able to call in, and I'm hoping you can hear me.
Yes. Can you hear us?
Yes, I can hear you.
Okay.
I just want to thank the committee for allowing me to sit on the Midwives Advisory Committee. I want to thank you, Leanne, for all the hard work you've done. I want to echo everything that Margaret said regarding the CM credential. It's really a waste that she's able to practice in the state but can't work in her full capacity. I just want to highlight from my written testimony the limitations that these rules, how they impact my ability to become integrated into the Medicaid system and bill insurance without the ability to diagnose pregnancy and pregnancy-related conditions. And other
What happened? It's her connection. Oh. Okay, we're gonna move on.
Will she submit written?
Yes, she did.
Email in.
Yeah, she did. So we have her written. Whitney, I don't know if you can hear us. We'll get back to you as soon as she's ready. Hold on to the next person. Loretta Mendoza, Pacific Birth Collective.
Hi, this is Kiana Rowley. I'm testifying on behalf of Moria Mendoza and Pacific Birth Collective. She was not able to be here today.
Thank you.
Can you hear me?
Yes.
Okay. Thank you so much for having us, to Leanne, and to the advisory committee for all the work that you've done. We stand on our written testimony, and we have a couple additional points that we wanted to highlight. First of all, we concur on the clinical definition challenges with the DCCA trying to redefine midwifery when it was written into the statute. And we would like to ask that the committee note that to the auditor for the revision of the licensure program, that definition be narrowed to include a clinical definition. And there's kind of three main points that we wanted to make. One is for the scope of midwifery practice, the definition, honoring of cultural practitioners, and clarifying on professional conduct to make sure that we're not overly persecuting, criminalizing, or restricting access to midwifery practice, which is so important for improving outcomes in the state. So once again, clarifying the clinical definition of midwifery and moving that to the auditor's plate so that that can be corrected legislatively. We want to say that we appreciate that Hawaii is a full scope state for nurse midwives, and that the intention be to offer a full scope for certified professional midwives as well as certified midwives so that they can bill insurance and that these practitioners can be accessible, but not at the expense of cultural practitioners who serve a very important community and are facing erasure. And with the current injunction in the law, we would like that to be reflected. So at the time of our testimony, we didn't have that final release from the courts, but we would like that to be reflected in the licensure rules or in the interim rules, that Papa'ololakahi has been found to be insufficient to protect these practitioners. And that is reflected both in the portion of the rules that states the direct Papa'ololakahi exemption, as well as in the unprofessional conduct. There's a line that says where anyone practicing without a license, and the aiding and abetting. There's several places that kind of circles back to this becomes problematic. So we just want to make sure that it's really clear that there is no infringement on people's right to practice their full practices without fear of criminalization. We also, as Pacific Birth Collective, we've been hearing from multiple licensed midwives with some inconsistencies, not being clear about the scope of clinical practice for certain situations, including breaches, twins, post-dates. So any rules that are enacted just need to be really clear, because any gray area that can be interpreted in different ways creates opportunities for misinterpretation, prolonged processes if there is a complaint filed. So just clarity around that. If you're saying that you're referring to the ACNM guidelines for out-of-hospital birth, is that a direct contraindication for home birth in the way that you're writing that and interpreting it? And then coming to unprofessional conduct, emotional harm is too broad and it sets an impossible standard. There's also a few lines in that whole unprofessional conduct, which are just very broad, non-specific. For example, what is appropriate action in line 4C, and how are midwifery practitioners supposed to be responsible for, sorry, I'm just trying to find the line. I refer back to our written testimony for that. And then one of the line items in, let me just pull it up so that I can be specific. So causing injury to one or more members of the public generally, I think that we would just like to reiterate that this is not fair or right to blame the midwife for any situation, because families choose the level of risk that they're able to take. So if informed consent is given, that sometimes in different situations, there may be a bad outcome. And that doesn't mean that the midwife is not acting responsibly, and that there should be some more detailed conversations around how to protect both the public and the midwife when they are acting in the best interest of the family, and that family may choose to take on a level of risk, which is their personal decision. And thank you so much for hearing our testimony. And we look forward to continuing to be a part of this dialogue. And I'm really proud of our community. I know that there are a lot of challenges with coming up with rules and processes that are not discriminatory towards any group, and trying to kind of elevate the accessibility within our state and within Hawaii, especially respecting the roots and the indigenous people of Hawaii and other nations who reside here. Thank you.
Thank you.
Officer Tashima, Whitney logged in over her phone. So it's okay too.
Sorry, what?
Whitney, she,
Okay, yeah, that's fine. Executive Officer Tashima. Thank you, Mr. Yoshimura. After Whitney, we'll do Miyoko, Aoki, and then Pua and To. And then we can start.
Aloha. Sorry for the technical difficulties. Can you hear me?
Yeah.
Great. So my name's Whitney Harrelson. I am a licensed midwife. I also sit on the committee, the Midwives Advisory Committee. I'm also a member of the Hawaii Homebirth Collective. And I did submit written testimony. My two main points on my written testimony are that number one, we removed the ability to make a diagnosis within the licensed midwife capacity. That's concerning for me for a couple of reasons. One, because I believe it will impact our ability to bill Medicaid and other insurance in the future. That is a goal. Eventually we'll be integrated into the Medicaid system. However, if we can't diagnose pregnancy, we can't diagnose pregnancy related conditions, we can't use ICD-10 codes for diagnosis, it really limits our ability to do that. And I think having our Medicaid population have access to midwifery care is really important. Secondly, my concern that I wrote about in my written testimony is the referral to the ACNM Midwives Clinical Bulletin on the provision of home birth services as the scope of practice for licensed midwives. Again, we've talked about this multiple times in our meetings that licensed midwives, certified professional midwives, we are not nurses. And so therefore we have a different scope of practice and different practice guidelines than those put forth by the American College of Nurse Midwives. And so I disagree with the reference in section 16-121-5 to that document. In addition, I kind of want to mirror what Kiana said here. It's a very gray wording where it says licensed midwives may refer to this practice bulletin. This practice bulletin places breech births at high risk. It places pregnancies over 42 weeks at high risk for home birth. So I really think the department needs to clarify if that is our scope of practice or if it is not, as defined by this document. And I just want to say that I have really appreciated my time on this committee. I do wish that the committee would move forward with more meetings instead of just pushing through the proposed rules. And I just want to thank you, Leanne, for all the hard work you've done and everybody at the DCCA. I've really benefited from licensure, and I hope that we can keep our licensure in a way that doesn't infringe on the rights of other people. And I also really want to speak on behalf of the certified midwives. You know, it's really a waste to have this credential allowed in Hawaii, but really kind of limit the way they can practice. And, you know, CMs in Hawaii could be a great asset to our maternal health care systems, but they're not able to practice at their full capacity. So thank you. I appreciate you all.
Next is Mieko Aoki Birthing Care.
Hi, Miyako. You should be able to enable your audio and video.
All right. Maybe she's just on there. Let's go to Pua. There
Okay,
she-
can you hear me?
Oh, yes.
Okay, sorry, I was having a very hard time with this. Okay. Okay. Okay, aloha. This is Mieko Aoki Stewart, my midwife, licensed midwife on Kauai, and I definitely stand strongly with my written testimony and suggestive edits of the draft that I sent him by the email. I understand you're not answering questions at this time, so yes, there's much clarification needed regarding defining the scope of practice that directly affects us. And I really just agree with railroading policies and rules through. We're talking about that these are going to affect the lives of people that we care for and how we provide care. And it's very, there's a lot of ethical things here that feel like is, again, not considered. And I do my work as a midwife very seriously and deeply with each family. And I don't agree with creating rules and regulations based on insurance policies or needs for insurance. First of all, that is not midwifery care in my eyes. I wanted to clarify one thing before I forget anything, before I go into it. I really think there is a necessity to create a subcategory for the CMs. As the law was created or railroaded through as well to become licensed midwife or for licensed midwives, for CPMs. I know that, and we strongly feel that the CM were thrown in there and has created a big mess. And all the rules, as we were reviewing the draft, it really looked like they were for birth centers and for ACNM or nurse midwives category of practice and or rules that I strongly feel does not apply to CPMs because CPMs are mainly single person, private, independent primary care providers. And we do all the work solo usually. We run our own administrative stuff, the entire ins and outs of running a business, and usually solo. And so there's even more reason to train our next generation of midwives. So I do support the apprenticeship and the PEP process to continue on the legacy of traditions and traditional practices of midwives too. But please stop putting CPMs into ACNM or nursing categories. We are not nurses. We're not nurse midwives. We are not doctors, obviously. And it does not coincide. It doesn't jive. It doesn't flow. It's not how we practice. So there's a lot of edits and notes that I sent in the email. But I also want to remind and or re-educate and inform that CPMs are the only profession specialized in home birth skills and practices. And that's what we do, just home births. And so this also includes the full spectrum of reproductive care. And we provide that throughout their lives, that they don't just have babies with us, they have care from us and with us throughout their reproductive years. And that does include the gynecological and menopausal nuances. Or so all of that to be considered in how these rules would be written. Please consult with licensed midwives and CPMs and home birth midwives who will directly be impacted. Every CPM, really, we're all traditionally trained midwives, and some of us who became CPMs just chose to take on the CPM credential as it became available. And then, of course, some states created laws that we need to have licenses, but that's more of the core of who we are. And as we provide choice to our clients, we're also human and midwives. We also need choices as well, and how to you really provide the best care for our clients, and our spectrum is big. um, and we are the only ones that provide breeches and twins services and care at home. No one else does, and so that is a very important specific CPM training that no other profession has at home. So we do things at home, and we're specifically trained for that and continue our education that way. So although CPM, the scope, maybe our practices is variable for each CPM due to their own training, but usually again, it's informed consent and the CPM's choice of comfort and or competency in providing such services to their families. And that would be, of course, through informed consent. Our families, and I'm kind of jumping around, but and I am definitely available for any questions, to answer any questions. But again, I saw that the ACNM bulletin, clinical bulletin, was kind of snuck in there. And again, we are not nurses. We're not nurse midwives. We do not provide the same type of midwifery care. And that's really important to be considered, and please consider that and try to understand the differences. If you need more clarification in the differences, we are available. But my big point is, please create another category for the CM and their rules and regulations, as it does not apply to CPMs. Thank you.
Are you ready?
Aloha, thank you. Hi, can you hear me?
Yes.
Hi, thank you for the time and opportunity to testify. In addition to my written testimony that I submitted, after hearing the testimony submitted today, especially the ones that this certification process, or these rules for the licensure and certification process pertain to, it's really alarming that so many of them that this is supposed to help their practice has been barred their practice. And so I'm really, being a community member, it's really confusing why, if we keep after, like Christy had said after the last meeting, we were in violation as the committee, and as a committee member, this is really alarming because this is new to me and I'm trying my best to follow the rules, but it's just alarming why there's so many things like the sunshine line being violated, the kite analysis being violated. It's making this process a lot harder. And so I'm just really confused on why there's rules already in set to make these things easier, and then being violated, and it's hurting the people that the whole intention of these rules is to make it a more qualified providers for our community. And so it's just really, I'm just wanting to say of how alarming this process is. And so at first I was had really minor adjustments to it, but now it seems like since the people that are certified and are licensed of it, there needs to be a lot more clarified. And so what I did write in my written testimony is that how the definition is super problematic because it's trying to throw a lot of midwives into, like, define a small category of midwives for all the type of midwives in Hawaii. And so I've said this before, but in Hawaii, it's been 131 years since the licensure process has been here, and Hawaiian providers that did Hawaiian medicine, they really were trying to work really hard with the Board of Health and these committees to get their own type of licensure, and it caused them because it kept, again, the same process that we're seeing right now, like history is repeating itself, that rules were made that wasn't benefiting the actual provider itself. And so when you're limiting their practice of what they were trained to do, why is the people that weren't trained to do that doing that? And because of this, we saw so the Hawaiian providers were the kahuna class of, and we don't, like, if you fast forward 131 years, that class was erased. And so it erased a whole profession. And there's really like a handful of them that are having to practice under law because of this licensure process. And so we've already seen the results of what happens when the licensure process is too constricting on the provider. And so I don't want to see that again, because, the 131 years that this process has been in Hawaii, it was supposed to improve the maternity morbidity, as well as, the whole experience of birth and pregnancy for the whole family. And it's done the exact opposite, because now Native Hawaiian Pacific Islanders are the #1 ethnicity to die. And Hawaii is the worst state in all of America with the worst prenatal care. And so we are repeating history again and again, and it's really concerning that why are we trying to limit the providers that are really competent in it? And so it's just that reiteration that licensure has the power to either support and give a lot of resources, like insurance and getting reimbursement for fees, because but if it's done right, and it doesn't seem like this process is doing right, it seems like it's doing what it did to the kahuna class, and it's actually aiming to delete a lot of the providers that are even not mentioned in it, because the midwifery definition, like, it's not it's a specific category of midwives with specific schooling, but it's trying to be all encompassing to all the different midwives, and it's making people illegal, like traditional lay midwives, the granny midwives, the Black midwives, the religious midwives. There's so many midwives in Hawaii that are competently already currently trying to serve our community. And so can the definition be, if it's supposed to regulate one class, can it regulate that one class without making others illegal, and others that are actually providing a lot of care for our community? So that's my biggest concern, is that reminding us of, history has already shown what's going to happen if we keep repeating this ability to erase competent providers, and it's going to inflame. We already are in a bad situation with the maternal health care, and it seems like it's going to get worse if the people that have been trained a certain way, like so many of the people that testified, and now they can't even do what they were trained to do because of these rules that were in place that was supposed to intended to help them. And so I would really appreciate if these the people that have the licensure are the ones that they're, the last in the community meetings, it sounds like their opinions are not being taken and putting into these rules. And so I know it's a really confusing process. I'm trying my best to understand it, just like many other people in this process. And so I just think that everyone of coming together to do it. But I think these rules, my final testimony now is that these rules are not ready to be voted on. And so that we don't do that. Can we please get a better definition of it that is, are we being really specific of it? And I thought that was a really good idea, that there's subcategories of midwifery. And so can we get more work to be done to understand how many different types of midwives are in Hawaii, and so who's providing care, and that they're not going to be made criminalized because they are providing proficient care. So that's just the main thing. And so thank you again for the opportunity to be on this DCCA community. And I look forward to more meetings versus trying to vote on rules and definitions that are extremely problematic. So thank you for this opportunity.
So that's all the written testimony that we received via email. Again, we got 2 more hours. We just went through 12 testifiers. And we have about 23, 24 other people on virtually. So we're gonna have to plow through those. So Wait, Alex. Oh, you want to break?
Yeah.
Okay, why don't we reconvene you got 2 minutes. We'll reconvene at 11. Want to take a little break? Okay.
We're gonna resume hearing testimony for the public hearing, and we're gonna be taking Zoom testimony at this time. I understand that Ki Nanikoho Hano's phone is about to die, so we're gonna take her out of order first. We do that, please.
Aloha mai kako, mahalo. Yes, I had actually planned to be there in person today, and unfortunately was brought to emergency with my daughter who's not doing well. So this is a very vital issue, very vital hearing, and I'm terribly sorry, honestly, that I can't be there in person, and I appreciate everyone who is. Thank you all for holding this space. I stand on the support. I stand on the testimony of Pacific Birth Collective, as I am also a board member. I also stand on the testimony of HIHBC, of whom I'm a board member. I do speak for myself today as a cultural practitioner of this work. We do not have a seat at this table. I'm grateful for Pua, who is able to be a voice for our people on this advisory board. I was not able to have a position myself. And I really appreciate the people that are doing this work, first and foremost. I don't think that the work is actually being done, is actually my biggest thing I want to say today. As the law was railroaded, so is this work that is, for years, quite honestly, since the law passed, the kuleana of the DCCA to create the appropriate rules and regulations around midwifery and its practice. It is supposed to be intended to support CPMs to practice and be licensed to the fullest degree in our state so that they can help with the maternal health care crisis that exists in our state. It is also ridiculous that CMs have from the beginning, and we have been saying this in the task force. Kalamai, I was also in the task force with the traditional seat. We have not been saying that it's not important for them to be a part of this, that they should not be seen or included in general. We didn't have them present, but what our biggest complaint is why are they included in a CPM law? They don't have the same pathways, they don't have the same exams and criteria, so please put them where they belong. We wholeheartedly support them and we need them. And we're so grateful that some of them are showing up to be able to practice and support, again, the maternal health care crisis that exists in our state. So please support them accordingly. Put them with CNMs, with who are holding the same equivalent level of training and exams as them. Same like the PEP, which we keep hearing again and again. The PEP process needs to be supported so that CPMs in our state have at least a fighting chance to obtain licensure and the certifications that you have now deemed required in our state, which are very inaccessible at MAKE standards from Hawaii. Those of you, some of you have heard many times, I'm sure, the testimony of those who have attained that from Hawaii, and none of them have done it wholeheartedly within our state. We are lacking preceptors, both for CNMs, CMs, and for CPMs. That's a huge one. We need more of them. So how are we supposed to create more of these folks if we don't have the people to support them to get those pathways completed? Okay, now we have the Board of Nursing and all these other folks, again, infiltrating a CPM process. Why are we held to their standards of which we are not a part of? I'm saying we because I consider myself not necessarily a CPM, but I've worked for over 20 years in our state with the CPMs that exist or have existed before their passing, which, even if they are still alive, do not qualify, as Rachel referred to her preceptors and her support, where she got most of her training. My preceptors and a lot of the folks that I've worked with in 20 plus years would not qualify, even though they're CPM in our state. They weren't MEC accredited, et cetera, et cetera. This whole thing is bogus. You guys need to do due process. You need to stick by the rules and regulations that actually you're supposed to abide by as this advisory board. as the DCCA, I think you folks are the ones that should understand these things first and foremost. This is like us learning a whole new language throughout these years, us giving up our families and our friends and our lives for years, over decades, to try to get people to do what is appropriate, what should be much like what you learned in kindergarten. Yeah, so let's do what is pono. Let's create regulations and rules for CPMs that make sense. Let's give them what they need to practice. And I'm going to say, if you guys are going to put someone like, CNMs and folks like that in charge of CPMs, you might as well put me in charge, because I actually attend home births for over 20 years. And we could put Malama Napua Ohamea. Why don't you refer to the people that actually hold lives in their hands at home, not someone who is working in hospitals or even birth centers. And I want to bless up all those people too, because we need each other. But what you guys are doing so far for years and years and years, I have witnessed this, and that's why I'm still in this game. That's why I sue the state of Hawaii, because you guys are not doing due process. You guys are not being honorable, and you are not supporting what the point of this law is supposed to be. So please reconsider what you're doing here. I wholeheartedly agree with Auntie Laulani. It needs to stop right here. Yeah? Do not move this forward. Do what is right. It's already taken you years to get to this point, and I'm sure that's why you feel the pressure to make these things happen, but it's not pono the way you're doing it. So please recognize that. Please humble yourselves. Please do the right thing, and please call upon those people in the communities that you know are there that can help support you to do this in a positive, proactive way, so that we can actually be efficient in serving our people and lessening the disparities, which are ours. Thank you so much.
Thank you. Right. Next, we have Krista's iPhone. Just as a reminder for Zoom testifiers, if you could please state your name and any organization that you represent.
Thank you. My name is Krista Olson, and I'm here today speaking for the Latch Project, which is a health equity project that is a joint venture of ECAS, Early Childhood Action Strategy, and Breastfeeding Hawaii, and working specifically on increasing access to breastfeeding care, and also recognizing that there's a continuum of care that is potentially impacted by the language of the midwifery bill and statute as it stands. And so I wanted to just point to a couple of things in the new proposed language that are of concern as we work. So we convene a team of representatives from insurance and from Medicaid providers and patients who rely on the scope of care across the islands to provide not only services around the time of birth, but during the prenatal and the postpartum time. One of the things that we see as a concern in this language is that inadvertently, in defining what a midwife is not, we've identified some concerns around the ability to practice for our breastfeeding support team, including board certified lactation consultants who are currently credentialed and providing services through some of our insurers, but also our perinatal community health workers who are trained in a very specific scope of practice. Our doulas as well are potentially impacted by this law. And so while we're really excited to see the potential for increased access to midwifery care and home birth care, the potential for insurance coverage for those folks who choose the home birth experience with a CPM. Inadvertently, we're finding in our work with insurers that a lot of the potential for coverage for doula care, for lactation care, things that might rely on a Medicaid state plan amendment or a Medicaid waiver are now on hold because the language of scope of practice here and the definition of midwife creeps over into the scope of some of our other providers. And so I just want to call out a couple of things in the language that I think are of concern. In the definition under 16-121-2, we see that when defining midwifery and identifying that it does not, what it does not include, some of the places that are, I think, intended to clarify the difference between a family member and a licensed midwife also kind of scoop up and toss out many of our continuum of care providers. So I just want to point out that under number 3 on page 121.3, that when we say that there's no compensation or consideration given, there's an absence of formal professional client relationship, minimal or incidental level of support or assistance are provided, no verbal or written representations about professional qualifications, skills, experience, credentials, license, or certifications. We have a whole continuum of perinatal care providers who are potentially impacted by this. The Attorney General's definition called out concerns, and this actually put some critical work in our state on hold until this language is cleaned up. And I see some efforts to do so, and I commend that I could see some more specifics. And I heard someone earlier say so eloquently that we need to focus more on what we do want in the midwifery law and not what we don't want. One of the things under scope of care, as someone who worked for Early Head Start for 20 years, supporting home visitors, I see that even our home visitors who provide peer support in our most vulnerable communities are potentially impacted by this as well. And I just want to highlight that when the scope of practice defines, particularly on page 121.6, the definition providing education and counseling related to the health care for persons with female reproductive systems, focusing particularly or essentially on healthy pregnancy and childbirth, postpartum period, care of the newborn, family planning and gynecological needs of persons with female reproductive systems. This is to a T what some of our continuum of care providers in the perinatal world do, and particularly do well in remote communities, in rural communities where we don't see a lot of clinicians, and that spillover, I think, has created, for those of us who are thinking about how to increase access to care and to pay for that care, particularly in underserved communities, a whole new set of complications. And we all know that what happens on the insurance end to get us to a point of credentialing and covering providers or allowing for them under a Medicaid waiver is a long, complex process, and it's easy to derail it. And I just want to highlight that, in fact, it has been somewhat derailed, I think inadvertently, but by the language of the midwifery bill and the attempt to carve a large scope for midwives has, by defining those things as only the realm of midwives and those who are already licensed clinicians, left out a whole array of folks who are often board certified, go through extensive training, but do not fall currently under the licensure board. So the alternative is, of course, for us to return to DCCA to provide licensure for all those other continuum of care professions, but they don't necessarily meet your standards for licensure in terms of potential for harm. So it seems like it's going to create a whole new scope of work that may not have been intended or anticipated. And I want to make sure that that's on the radar and just point out that we have this hui of folks that meet under the auspices of Early Childhood Action Strategy, and we're happy to provide more specific follow-up and just make sure that this law is clean and clear and applies to the work of our midwives and allows the work of our other perinatal providers to continue as appropriate. Thank you so much.
Thank you, Krista. Before you go, could you please spell your last name?
Sure. Olson, Olson. And Early Childhood Action Strategy and Breastfeeding Hawaii are the two collaborators that convene Latched, which is our project working toward coverage.
Thank you very much.
Thank you.
Yes, I believe next we have Lynn Velasco.
She's breastfeeding Hawaii.
Morning.
Good morning. Hi, thank you for allowing me to speak today. I did include a statement. Can you hear me?
Can you say your name and the organization you may represent?
Yes. My name is Lynn Velasquez. I'm a certified professional midwife and a licensed midwife on Kauai. I did include a written statement along with Mieko. So you guys have received that statement. That was a joint statement by both of us. We practice here on Kauai. We serve the community here on Kauai. I've been a practicing midwife for over 30 years. I've been licensed in South Carolina, Missouri, have practiced in Indiana for over 24 years. I was trained by route of apprenticeship for over 5 years and then chose to become a CPM through the prep process. I've been a CPM for over 16 years now. Being in Hawaii has been a learning curve for me. Things are done definitely different here than they are in other states. In other states, we're able to obtain birth certificates if we have a bad outcome at home, or if a baby dies during prenatal care. We have an ultrasound to confirm that. We can contact the coroner, let them know what has happened. Families can, if they choose to, have their baby at home, deal with the death certificate at home, and then transfer their baby straight to further services for the baby's funeral. There's not a big investigation of the midwife or the family and the cause of the baby's death. And that is one thing that I have heard from a detective here that happens when there is an outcome of a baby's death here in Hawaii when attended by a midwife. And that's very alarming when babies don't always survive, even in the optimal conditions. And part of your rules and regulations do not address the ability to have obtain birth certificates or death certificates. And then you talk about language in here on professional conduct. And that's very concerning when you're talking about, you know, we have the right, people have the right to choose where and whom they want to give birth with. And that should also include if a child does not survive during their pregnancy, where they want to deliver that baby that's not alive. That's their informed consent and their informed choice, and they should not be under investigation for that. Nor should the midwife, and nor should that be considered unprofessional conduct. I don't think that's endangering the welfare of a client or unprofessional conduct. And I think that that should be some kind of language in there that says that women are allowed to choose that. There's a lot of language in here that feels like it's addressing CNs and not CPMs. There's stuff in here that talks about referring to the nurse midwife bulletin as a CPM. I refer to the NARM guidelines and the CPM guidelines, not the nurse midwife guidelines. I was not trained in the hospital. I do not do Pitocin or Cytotec or use any of those drugs. I do not put women on IVs to induce them or augment their labors. Those are things that CNMs might use, or a CPM might use, or a doctor might use. Everything that I do is things that are meant for a home birth setting. So having rules and regulations and language that centers around a CNM or a CPM in our rules and regulations seem totally inappropriate for certified professional midwives. Our training starts at home from the very beginning and continues throughout our training. All our prenatals are done at home. All our postpartum cares are done at home. All our births are done at home. None of it takes place in an institution. Sometimes we may attend births at a birth center, but that is not our primary training. At the point that we start doing our book learning, we are doing our home births. They're hand in hand. We do not do 2 years of book learning and then start attending births. So during those 5 years that I'm attending births and training, I have a lot of groundwork laid and what a complication might look like at home and how to handle that and what a transport might look like. how to handle a breech delivery, how to handle a twin delivery, how to help a baby if they might have a little bit too much mucus or fluid in them, how to help a baby that might need a little help breathing, how to help a mom if she might have a little bit too much blood loss. We're trained in these. So this language just is very dangerous for mothers to feel safe in hiring a midwife that's going to respect their choices and their boundaries. And what we're seeing in other states that are becoming so restrictive in their languages is that midwives cannot safely attend them without violating the rules and regulations. So it puts the midwife in jeopardy. So the midwife says, I can't attend you. And then families are choosing to go unassisted. And we're seeing that more and more, that families are choosing to do free births and midwives are being left out of the picture because rules and regulations are becoming too restrictive. We need to have less restrictions in the rules, and they need to be protective of the family's choices. We need to make sure that we are remembering the training of the midwives. Now, I understand that Hawaii is including CNNs in our language, so we need to have a subcategory for them. We need to make sure that, yes, they are taken care of, but also say that we are two different types of care providers, and therefore we need to have two different types of rules and regulations for those providers, and not include us all in the same document or the same language. And I stand by the document that I submitted, and I thank you for your time.
Thank you. Don't see any hands on Zoom at this time. Would anyone else like to testify on Zoom?
You want to testify? Can you raise your hand?
Raise your hand. Yes, Ms. S.
Yeah, then I would just call. Other names.
Oh, I see. Just allow it and just say it. Ask them to raise their hand. Okay. All right, so I'm going to go down the line and just call your name, and if you would like to testify, then please raise your hand. Laura Ocasio? Yes. Amanda Moore? Michelle Palmer? Danny Chow? Bree, can you come up? Ashley Mizuo. Carol Owens. Ayla. Alexa. Keaton Kleinhans.
He's with DCCA.
Just
Candace, because there's two Candace.
Oh, yes.
On the top, Candace on the bottom.
Candace. And Steph's 14 Pro Max.
This. Yes. Yeah.
Oh.
Good almost afternoon. My name is Daniela Martinez. I'm a licensed midwife. I'm a CPM, certified professional midwife, practicing here on Oahu. Now, one main point, it's regarding the concern that's been mentioned a few times of requiring certified professional midwives to refer to the ACNM guidelines. And why that's not appropriate for CPMs who are not nurses. I have to read from my phone to be. It's from the. It's directly from the guidelines. It requires midwives to maintain current certification by the American Midwifery Certification Board. That is simply unobtainable for certified professional midwives. So even if we wanted to, we cannot abide by those guidelines. So if you look through the requirements, you'll see that bulletin. So I hope that just highlights how it does not apply to CPMs. We're trained differently, different schooling, different requirements all around. So I recommend language that makes it very clear that the ACNM guidelines should be referred to by the certified midwives. That is very appropriate. That I can speak for them, but they seem to agree that that is appropriate for them. So that's the main point I wanted to highlight. Thank you for your time.
Just for everyone's information, the public hearing will remain open till 1 p.m. So we will still be here to receive any testimony. If you would like to submit testimony, then please raise your hand on Zoom.
We're just gonna put the room on mute.
Yeah.
You guys are great.
All sorts of shit.
Hi, everyone. Anyone that's just joining us right now, we're still accepting oral testimony. So if you would like to speak, then please raise your hand.
It was Ezene Dawson, I saw.
One more time, if anyone joining us would like to testify, then please raise your hand. I'm not seeing any hands raised, so we'll be on standby.
Okay, Ezene's hand.
You can unmute yourself. Ms. Dawson, if you'd like to testify, you can unmute yourself and turn on your camera, please.
Apologies, I'm using my phone to call in and having had a challenging time trying to find the raising hand button and unmuting myself.
You can please state
okay.
your name and any organization that you represent.
My name is Ezene Dawson. I'm a licensed certified professional midwife. I'm representing myself. And I was on the call earlier. I was able to hear some of the testimonies that were shared earlier. I had not submitted written testimony originally because I really wanted to take some more time to digest all of the interim rules and considering the recent hearing that occurred, I wanted to also just kind of see how all of that would play into it. But I'm representing myself, and what I wanted to share today basically is that I am appreciative of all of the work that is constantly being put in by so many midwives and DCCA. Is not necessarily easy answer that makes everybody happy, but I do recognize also the need for it to be done properly and in a way that allows for the community to have an input or have their voices heard. And that's why I wanted to, at this time, just testify from my experience as a licensed midwife, the need that I have to be able to also work with other midwives or apprentice midwives who are wanting to train in the apprenticeship model, which is the PEP process, which was not included in the law. And I wanted to be able to recognize that I think someone had said earlier, the need for that process to also be highlighted or understood or accepted because of the nature of the exams that we all, similar exam that we take, the same exam that we take as a PEP student or as a MEEC accredited student. I recognize that it is important for those qualifications through that exam to be able to, it's important for them to be able to also work alongside midwives such as myself. I also wanted to share that I feel confident that many of those who have spoken prior have shared concerns about the formalities that have happened along the way. And I also echo those similar concerns. I wanted to highlight that because I think that those of us who are actually practicing midwifery to and actually serving the community actively need to be able to have a stronger say because this is impacting the work that we do. So I think that's really the bit of information that I wanted to share, and I just want to thank you for a moment to be able to express that.
Thank you. It's not ready.
I'm done.
Hi, Michelle Palmer, you can unmute your mic and turn on your camera if you'd like to testify. Please state your name and any organizations that you're representing today.
Hi, my name is Michelle Palmer. I am a certified nurse midwife of 26 years. I'm one of the board members for the American College of Nurse Midwives. And I'm currently working on the island of Molokai at Molokai General Hospital as a certified nurse midwife. And I just want to echo Margaret Reagan and Annette Manette's testimony regarding the CM credential. One thing I'd like to clarify is that CNMs and CMs are educated and clinically trained to work across settings. So we do receive training for attending births at home, in birth center, or in a hospital setting. And I've done all three throughout my career. I also would like to clarify that we take care of individuals seeking care throughout their lifespan. Where we differ and what is problematic around the drafting of these rules and regs is that you have different credentials placed together that really don't align, which has amply been discussed. And what else is problematic is that, you know, I've always understood as someone who's served on the Rhode Island Department of Health Midwifery Advisory Council that the statutes or rules and regulations that are put in place are really about the public being able to be informed about who they're seeking care from, right? Because it is their constitutional right to be attended by and where they choose, which is separate from what these rules and regulations or statutes have to do or to define. But I do hope that the DCCA can move forward in a way that honors the traditional midwives in addition to the certified professional midwife and the certified midwife that we're discussing today, so that people who are seeking to provide care can do so in a way that is in alignment with their history and their culture, and that recipients of care can be clear on who they're receiving care from. One of the things, you know, in Rhode Island, we have had the certified midwife credential in place now for quite some time. It works really well. Certified midwives are able to practice to the full scope of their practice, which includes the ability to be employed, self-employed, if they choose to have a home birth practice, or to be employed at a birth center if they choose to start a birth center, or within a hospital setting where they are recognized in the rules and in the credentialing and privileging procedures. They can also work doing gender affirming care, doing care throughout the lifespan, at family planning clinics, in private practice, or in federally qualified health centers. So it would go a long way in helping to narrow the gap in Hawaii to move these regulations through that recognize different credentials so that there can be an increase in access to care in this state, which, as we all know, has wide gaps geographically and with the provision of resources across the different islands. And so thank you so much for hearing my testimony today. And I look forward to following your process that I hope will afford both the recipients of care in Hawaii and the providers of care the structure that's needed in order to provide all citizens of this state with the care that they need. Thank you.
Thank you.
Right, well, that's why Annette was saying when she could follow them in.
If I follow them in.
No, but she has hospital,
we
she
have
would
a
follow
handout.
it, she had
We have a
hospital
handout.
privileges.
Someone's gonna testify.
Amanda Moore, you can unmute yourself and turn your mic on. Provide testimony if you wish.
Okay, can you hear me?
Yes. Hi, could you please state your name and any organization that you represent?
Hi, my name is Amanda Moore, and I'm a licensed midwife in the state of Hawaii and Oregon, and I'm also a certified professional midwife.
Proceed.
I was licensed in Hawaii since 2022, and I am still learning all the process of what is being set forth as rule and regulation. And I've been listening to today's testimony and reading through the licensing laws, and I would like to point out a couple of things that could be of use. I come from a state previously where licensure was implemented in my time as a midwife, and they also included unlicensed midwives in the licensure. And with licensure and unlicensed midwives came the right to file birth certificates. And licensed midwives and unlicensed midwives were defined. So there were two different pathways to become a midwife in the state of Oregon. And that was all encompassing for all the midwives, traditionally trained, PEP, MEEK accredited, but the pathway of licensure was defined as the licensed midwives were able to carry legend drugs and devices. We were able to bill third-party reimbursement, insurance companies, and we were able to accept payment and advertise. So there were two very distinct differences. And unlicensed midwives, or the traditional midwives, had a different set of regulation. But the defining role was, with licensure came payment, third-party reimbursement, legend drugs and devices. So in this rule and law, I have found a couple things that I think could be looked at. And maybe I am repeating situations that have previously been stated. But I definitely think that a licensed midwife, the place of care should be defined, and that should include home and birth center. Licensed midwives have the right to practice in a birth center and in a home setting. So I think defining where our care can take place is imperative. I am not a CM or a CNM, and there are many regulations and pathways to education that define those roles. So then that leads into defining the differences of credentials and really clarifying that in your regulation. CNMs have gone through nursing school and continued with their midwifery certification. And CPMs are not required to go to nursing schools. So I think that defining the credentials is really important, because licensure, in my opinion, is based on the foundational let me restate that. Licensure is a public health foundational piece, so that when women are choosing their route in case care methods, that they are educated in the choices they're making. So defining credentials is really important, I think, so that the public knows what they're asking for and receiving. Informed consent is another foundational piece that I think should be implemented here, that the woman is making the choice with who she seeks care from and the choices she's making along the way, whether it comes from ultrasound, lab work, post dates, whatever. The woman ultimately should be able to choose, but the midwife also should be providing informed consent so that the woman is knowledgeable in the choices she's making. There were a couple other things. The renewal and restoration of licensure, that is based on the NARM certification, and NARM certification is every 3 years. And so when we recertify for NARM, we are supposed to also have our CEUs and our CPR and NRP. I personally feel that anybody practicing in an out-of-hospital setting should be currently certified in CPR and NRP. So with licensure, maybe we could submit current NRP and CPR, because those are life-saving practices that we should be current in, and they can overlap with the CPM recertification. So that's just something I noticed that I think is profound for the safety of everyone. Yeah. I'm just looking through my notes. Let me see here. In section 16-121-4, the scope of practice, underneath D3, it says female reproductive systems. And because we're living in a time where we want to be all inclusive, you may want to consider putting in pregnant person. And then there's also a part of 5 in here, initiating and maintaining accurate records. So defining how long we are to maintain records would be really critical. Some states require for a chart to be held for 21 years. Some states require 8 years, especially when it comes to infant and newborn care. There's just a couple, there are some vague things. In section 11, participating in joint periodic evaluation as peer review, maybe we should include the verbiage sentient events. And then I have heard the testimony today about the assistant aiding and abetting. And I was trying to find that in this rule and regulation that's being set forth, because I wanted to discuss that as a midwife who will help other midwives, or I'm also a NARM preceptor, so I will also train student midwives. And I think that that is a concerning statement. And if it becomes rule and regulation and law, that should definitely be reviewed. As a student midwife, I assisted the midwives many times and was not responsible for the choices or the care provided. And as a midwife now, when I ask another midwife to come in because it's a harder birth or because I need more support, it is not her responsibility either. It's not her client. She has not initiated care. She's not responsible for the woman's choices and the decision making. She is there to support the midwife clinically in the background. So I'm wondering where that's written, because I'd like to really read that rule, and I can't find it. Does anybody know where to direct me?
Was something I made a statement about. It's under
Unprofessional conduct.
unprofessional conduct, 16-121-7, it's number 1.
Okay, thank you. I really find that that is concerning. So I'm going to look at that really quick before Okay. Which section was that again? Under 121-7, what number?
Number 1.
Number 1, okay, impersonating. Oh, yeah. So that maybe should be reevaluated. The assistant is usually responsible for taking notes, helping with medication as the midwife orders. She is not responsible for patient care. She is there assisting the primary provider. So that really needs to be defined or taken away from rule and regulation and law. Because that individual, okay, say there's a doctor in the room. This is just something to consider. Maybe there's a physician in the room who is somehow related to the family. If that physician is in the room, they hold the higher license. So now are they responsible because they are related? The person in the room who holds the higher license is usually the one responsible. So I think that this is a really concerning addition to law. It has a lot of variability and a lot of different scenarios, and maybe defining what an assistant is and their role would be more appropriate. So that's a concern I wanted to also concur with others before me. A student on her path to becoming a midwife is not responsible for the midwife. Or a midwife who aids another midwife is not responsible for that midwife's relationship with her client. Home birth midwifery care is just so different than clinical hospital care. And I know we're trying to define safety measures for the public and to define licensure in Hawaii. And thank you for everyone for their testimony today, and that's my input.
Thank you.
Thank you.
Candace, not Candace, oh, Candace, you need Candace.
I asked earlier if you wanted to raise your hand. You did not raise your hand.
You're saying nothing, you're saying. Next to Will and William. You know Candace. I thought something popped up for her. She doesn't, she joined the meeting room. She left and came back. Maybe I should just stay.
All right, everyone. So that's going to conclude the oral testimony on the proposed amendments to the rules. Is there anyone else who wishes to present testimony at this time?
Raise your hand.
Yes, please raise your hand if so. All right then. So this public hearing is adjourned. Thank you all very much for attending and participating today. Take care.